Some new revelations from the full report from the Fulton County Special Grand Jury released today. It actually shows that the jury recommended charges for a lot of people beyond the former president and the other 18 defendants indicted last month in the election interference case. That list includes Republican Senator Lindsey Graham from South Carolina, along with former Georgia Republican Senators David Perdue and Kelly Loeffler, along with Trump's former National Security Advisor Michael Flynn. So why weren't any of them charged? Former Georgia prosecutor Chris Timmons is here to break it all down for us. So, Chris, look, you're a former prosecutor there in Georgia. You've experienced all kinds of RICO cases. What do you make of the DA's decision here, and why do you think it didn't go farther for Graham and others?
So, Kira, it could be for a number of reasons. I mean, the biggest reason, and probably what everyone suspects, is that these are people who cut immunity deals, meaning that in exchange for testimony, they remained outside the indictment. And so they would probably be listed as what you see on the indictment as unindicted co-conspirators. The reason why they're named in the special purpose grand jury document, but not in the indictment, is if you put somebody's name in an indictment, but allege that they're an unindicted co-conspirator, you violate their Fifth Amendment right because you haven't given them an opportunity to answer the charges. But some other reasons why they might not be in the document would be that the case is already complicated as it is with 19 defendants. They may not fit neatly within the indictment as it's written. There may be some other reasons just logistically why not to do it. But my guess is for a number of these people, they're unindicted co-conspirators who have a deal with the state. We'll see.
Okay, we will see. More to come for sure. So we just heard from Senator Graham, who said what he did was consistent with his job as a U.S. Senator. And then he goes on and says he warned we could be opening Pandora's box by continuing to pursue what he calls political prosecutions. What's your reaction to what he had to say?
Well, so I know some of the members of the prosecution team, and they're not motivated by politics. They're motivated by the facts and the law. But anytime somebody is accused of a crime, they're going to have a reason why they shouldn't have been indicted or even accused of that crime in the first place, or listed as an unindicted co-conspirator or voted on by the special purpose grand jury. So I mean, he's got to say something, and that's probably what he's going to say. I've heard that before when I've done public integrity prosecutions against elected officials. They always claim that they're targeted because of politics, not because of what they did.
Right. Well, so is it possible that Graham, Perdue, and others are off the hook now?
I mean, it is a possibility, particularly if they cut a deal. My guess is with Lindsey Graham saying what he said in the press, that's probably not the case. I don't think you would bite the hand that feeds you by suggesting that it's political when at the same time you've got an immunity deal. And they could be indicted separately down the road. It may be something where the DA's office decided that, you know, look, with 19 defendants, they've bitten off quite a bit. And if you bite off additional defendants, it's going to be more than they can chew. They're going to be stretched pretty thin already, given that they've got a massive trial underway in Fulton County with the young thug YSL RICO case. Then they've got this case involving 19 defendants, which may be split in two. To open another front would potentially be disastrous for the DA's office. So I suspect that before they do anything, they're going to get rid of, or at least in some way handle the 19 defendants that are currently indicted.
Yeah, talk about two high-profile cases. I forgot that there was so much going on there in your state. So you've said that Willis's plan to begin her RICO trial in 6 months was ambitious. That's what you told me last time. But that it's likely, you know, that she knows exactly what her case will look like after reviewing the report. What do you make of the strategy here and the way she's approaching it?
I mean, so curious. So my statement was based not on the DA's office, but rather on the defendants. I think the DA's office was ready to go to trial when they stepped foot in front of the grand jury that just passed on this indictment and returned a true bill. And my reason why I said it was ambitious was because you've got a lot of documents that are going to have to be reviewed by 19 different defense attorneys. When someone files a speedy trial demand, what they're actually saying, Kira, is that they are ready to go to trial that very second. And in fact, if a judge wanted to, upon receiving a speedy trial demand, they could call up the attorneys, have them report immediately to court, have jurors report immediately to the courtroom, and start within 5 to 10 minutes of the speedy trial demand being filed. So once the speedy trial demand was filed, then that it's no longer ambitious, it's reality.
Love having you on the show, Chris Timmons. Really appreciate it. We'll be talking soon.
Thanks, Kira. I appreciate it. Thank you.
You bet.
Hi, everyone. George Stephanopoulos here. Thanks for checking out the ABC News YouTube channel. If you'd like to get more videos, show highlights, and watch live event coverage, click on the right over here to subscribe to our channel. And don't forget to download the ABC News app for breaking news alerts. Thanks for watching.